Hey everybody, this is Caitlin with Mr. Ron LeGrand for another Ask Ron
Hello.
this week.
Well, just me this week. Don't have any people sitting around me, so I'm all you get. By the way, I'm heading for Dallas here in a couple days, and I'm actually going to a seminar. It's the Dan Kennedy Super Conference thing. Just so you know, I'd actually go to seminars. Plus, I'm in a mastermind group that cost me his group that cost me $33,000 a year just to go to Cleveland 3 times a year. So I'm a really good example of why you should always be learning, always be hanging around people that can give you information that you don't have, regardless of what subject you have. By the way, while I'm out there, I'm going to take my wife. Rarely does Beverly go with me to these places. Now, she won't be in the seminars, but on Thursday night, we are going to see South Fork. Now, I don't know if you know my history or not, but in 1982, when I attended my very first seminar, I came this close to not attending because Dallas was on TV and J.R. Ewing was my hero. And there was no DVR to record it. What if I'd have made the decision to watch J.R. that night? So I'm going to go out and see South Fork because I've always wanted to see South Fork. And then on Saturday, we're going to take a tour where the Kennedy assassination was out there. So we're going to make it a combination play time and work time. And I'm telling you, it's very rare I get to take Beverly with me. But her favorite place to go is the casinos, and she plays video poker. So there is no casino there, so I'm lucky. All right, who we got this week, Caitlin?
Okay, well, our first person is Chris Khabbaz from Texas.
Chris from Texas, where I'm going.
Hey, Ron. What is the best type of property to buy in an IRA? Is it subject to or with
That's
a
a very
long
good
term?
question, Chris. Very good question. Well, the answer is almost any kind, but with one exception. If you pay cash for a house and the money's in your IRA, that's a great deal for the IRA. If you, however, pay cash for a house, let's say you're buying a house and paying cash for it, and you're borrowing private money on it to buy it and renovate it, I'm not saying you shouldn't do that in your IRA, but if you do, that's going to trigger UBIT. That's UBIT, unrelated business income tax. So you're going to pay tax on that gain even though it's in your IRA. So still better to have the profit growing in your IRA tax-free forever, but just know that one will trigger tax. Now, if I buy a house and take the debt subject to, that is going to trigger tax as well, because UBIT is triggered by debt that comes with or that you put on the house. However, recently I learned that if I buy a house on a wraparound deed of trust, which is what you would do out there in Texas, that does not trigger UBIT. So you can buy them from the owner with a wraparound deed of trust and put them in your IRA and not have to pay taxes. So any deal you do that's like wholesaling where you never even buy it, or a sandwich lease option, which a lot of people are doing out there, they just put it under contract for a lease option and they flip the lease option because you can't do lease options in Texas, but your seller can. The owner, that occupant of that house can lease option it out. So some people are actually just doing the AX deals. Those are good for your IRA because there's no debt. A lease option is not a debt. So anything that doesn't trigger UBIT is great for your IRA. And I would strongly encourage you to buy as many of them in there as you can. And I use Quest, and they're in 3 cities there. They're in Houston and Dallas and Austin, Texas. So my IRA is right out there where the company is.
Awesome. Okay, our second questions, well, he actually has several questions,
Okay.
is from Chris DeSisto of South Carolina.
All right, Chris?
Okay, the first one is about lease option assignments, and if this setup allows the tenant buyer use the money as a down payment later.
If you assign any contract to the tenant buyer, they will not be able to use that money as a part of their down payment. This is why I do not assign contracts to tenant buyers. If I've got a contract with the seller, let's say it's a lease purchase from the seller, then I will sublease it out to the tenant buyer for a higher price and get whatever I can down. And then if I want to get out, I will simply go back to the seller and say, hey, I put this tenant buyer in the house. I think they can qualify for the loan okay. I've screened them, they look pretty good. Would you prefer that I assign my contract with the buyer to you, Mr. Seller, so that you can collect directly from the buyer and I will just exit? That's how I do it, because that way, if I'm lease optioning it to my tenant buyer, they can show whatever they gave me as part of their down payment, because that's what it is. It's a down payment or an option deposit, same thing. But if I just assign my contract to them, they cannot show that. So I do not assign contracts to owner occupants, period, for that reason.
Okay, his second question is, how do you get the mortgage broker to understand that you can apply the option consideration as a down payment even if the check is made out to the investor?
Well, I don't know why you're trying to get the mortgage broker to understand anything. It's the loan processor that needs to understand it. They may require a copy of the option agreement, and they will most certainly want to verify that you actually got the money and it went into your account, which makes a good point that you ought to create a deposit slip and put down payment on it or option deposit on it so that it's pretty clear what the intent of the money was for. Now, so if you're having a problem with them understanding that, you probably need to get them to get their boss or get another loan processor, one of the two, because it's pretty clear. They might want a copy of the lease purchase agreement, which clearly states it. And you know, all that bothers you. I'll tell you what, I've done quite a bit. When they tell me they're going to go get a loan, if they tell me, half the time they're practically ready to close before I even find out about it. But if they told me they were going to get a loan in advance, I'd say, well, listen, let's make this easy. And well, if I have, let's say I own the house, and now I lease optioned it, and 2 years later they want to get a loan, I just simply create a new contract. I'll create a new contract showing the date that they moved in and showing that they've given me an earnest money deposit of whatever it is, say $20,000, and that comes right off the purchase price. Now all they've got to do is take that new contract to the bank, and of course that's business as usual. That makes it a lot simpler, assuming you're going to have problems with the bank. In fact, some of these processors tell me that that's what they want anyway. I hope you understood that.
Okay, his third question is, do you have or know of any national mortgage broker that I could send the tenant buyers to so they can get an option fee applied?
You should contact screenthetenant.com, because he literally takes his clients after he's cleaned their credit up and works with lenders to get them approved for loans. That's the best thing I can think of right now. Screenthetenant.com.
Okay. And his fourth and final question is equitable interest.
Yep.
If the magistrates bump an eviction attempt up to the circuit court because of the option, would it be treated like a NOD and have to go that route if the judge sees it as an installment contract?
I think what you're asking me is, if they put a big old down payment up on a lease purchase, can the tenant buyer force you to foreclose on it? And the answer is maybe, and that depends on how big the deposit is. It's pretty normal around the country. If they put up at least 20% and you have to force them out, they can force you to foreclose on them. That is true. But anything below that is really totally up to the judge and the state law required. So this is a question you probably should ask your attorney. But honestly, the best thing to make sure you don't have to deal with that is to deal them out rather than try to force them out. I can't remember the last time I've had to force a tenant buyer out of a house, but I'm sure there have been. I just don't remember them. But if I did have to force them out, I'd do everything I can to keep from evicting, just because of that risk of them sending it over to the civil court and making me go through a foreclosure. But if I tell you right now, if they put me into a foreclosure mode and I have to go file it, I'm going to make it real clear to them that I am going to destroy your credit on the way out, and I'm coming after you personally for all the back due payments and all the court costs, which you are allowed to do in your agreement. Now, again, I try to deal them out. I'd rather give them money. Let's say they gave me $20,000 deposit and now they can't make their rent, they want to move. I'd rather just work with them. I'd just go to their house and say, listen, let me help you, because I don't want to ruin your credit. I don't want to take legal action on you. And you know darn well I'm going to win it, whether it's a foreclosure or an eviction. And you know I'm going to wipe out your credit in the process. And by the way, just so you know, I'm going to come after you until I collect what I'm owed. But we can avoid all that. And let me give you a couple of $1,000 if you're out by next Saturday, and we'll call it quits and leave as friends. I've found really very few situations where I couldn't deal my way out.
Okay. Do you have any idea what cost to do something like that?
That depends on what state you're in. For example, here in Florida, I got to pay $3,000 just to file foreclosure if I want to foreclose. Well, the good news is, so do they. Okay. But No, if I have to foreclose them out and the judge leaves me no choice, then it costs what it costs. It's the cost of doing business. Of course, I'm going to get it right back when the new tenant buyer goes in the house. But I don't know how many months it's going to take you in South Carolina. It'd take me 6 months here if I had to go the distance. 6 months. So that's why I do lease purchases, so that I can evict them. But again, that is the worst case. Boy, we're sitting here talking about the worst case. I have never in my entire life had a judge rule a lease option as if it's a foreclosure. On the other hand, I probably hadn't been 2 or 3 times in my whole career where we've even had that discussion. So it's not like I have a very good track record on it.
All right. Our next question comes from Chris Monroe. We had a lot of Chris's this week.
We sure do.
Missouri.
Missouri. Okay.
Yes. I've been finding pretty houses quickly, marketing them for tenant buyers, and some are ready to move in before I close the subject to deal on the seller's side. Would you suggest waiting to close with the tenant buyer till after the seller's side closes?
Chris, did you actually ask me that question? You just asked me, would I suggest that you actually wait till you own the house, till you put a tenant in the house? Come on, Chris. What's the only possible answer I could give you? If you go putting tenant in houses you don't own, and I'll tell you right now, you're going to have a bad hair day if somebody reports that to your local state attorney's office. You must own the house before you can put a tenant in the house. And I mean take title to it, Chris. Or you must have a lease with an option to buy that gives you the right to sublease it with an option to buy. Don't you even think about putting a tenant in a house or taking any of the tenant's money until you close on that transaction. Now, I'm okay if you're taking a refundable deposit from the tenant buyer while you're waiting to close, but if you don't close, that deposit's got to go back to that tenant buyer. But you cannot take the rest of the money and hand them the keys until you own that house or your lease option agreement is signed by the seller, and that gives you permission to go ahead and put a tenant buyer in it. Gosh, I hope what I thought you meant was not what you meant. And just for the record, subject to is not necessarily the way you want to buy them, because there's problems with that. Not for you, but for the seller if they ever want to go qualify for another loan. You might want to go track down some lessons here on the downside of subject to on the Gold Club. Because if you take these houses subject to, your seller is not going to be able to go qualify for another loan. I hope you understand that. Because you're going to kill their debt ratio most likely. They have nothing to show that they're receiving any money from you to wash out the debt that's still on their credit report. You might want to consider changing your buying method to a wraparound mortgage or a wraparound deed of trust, whatever's in Missouri, so that they can prove now that they got an incoming payment coming in to wash out their debt. I mean, even if you're paying the bank directly, at least they got a document that says they're receiving the income to wash out their debt. Because without that, they're not going to get qualified for another loan. And the problem is, they don't know that until they actually go apply for another loan. And they're all mad at you and coming back in a huff and a puffing. And you can prevent all of that future crap if you just buy it with a wrap.
Alrighty. Our next one's from Luke Mitchell of Georgia.
Luke?
So this question is in relation to one asked last week.
Okay.
In relation to the ejectment law, so this was the eviction / ejection question, it can cost considerably more and takes as long as a typical foreclosure.
Okay.
This is the main reason for my hesitation to do a lease options in the market. The ejectment law is very different from a simple eviction.
Okay.
It costs in time and money are much closer to that of a traditional
Okay.
foreclosure.
So that's why I lease purchase houses here in Florida, to avoid that. But again, we just covered that. In the rare instance somebody takes it from a rental to a foreclosure, you just deal with it. And honestly, they got to put up a big bunch of money before they even have the right to do that. So I wouldn't worry about that if I were you. I think he was already in the middle of one of those things, wasn't he? I don't know.
Yeah, I have the question from last
That's
week.
why you have an attorney, sir. You let the attorney guide you. And if you have to do an ejectment, you have to do an ejectment. Get over it. Get over it, learn from it, and maybe whatever you might have made a mistake on this time, you fix it on the next time. That's how we get smart. That's unfortunately, sometimes it's painful.
He asked, should I seek out another city or town close by with more investor-friendly judges to avoid any headache?
How do you know where the investor-friendly judges are? There's no way you'd know that. And I think you're creating a problem here that usually doesn't exist. And I wouldn't go be trying to move my area just because of some fluke case And, you know, I don't know enough about the case. I don't even know if it's happened or just as hypothetical for you. But if it's hypothetical, I think you should quit worrying about it. And if it's happening, it's probably only a one-time shot. Look, treat people right. Try to deal them out. You'll never even get to court.
Okay. Our next two questions and our last two questions come from
One more on that, though. This is why you close with attorneys also. Your attorney's got all the proper documentation, clearly disclosed that the deposit was non-refundable and should be there if you ever do get to court to defend you. And I promise you, with that attorney in that room that closed it, that other side is already on the bottom of the ninth with 2 outs because the judge knows it was closed properly and fully disclosed. So that's why we close with attorneys.
Okay. Our next question comes from Tim Barnes of New York.
Tim?
Hi, Ron. Can we buy houses with owner financing and or with lease options, homes with a VA or FHA loans
Yes.
on them?
Of course. I've bought a lot of them. And Tim, in New York, you will need an attorney because it's the law, thank goodness, to do the closings. But it doesn't make any difference what kind of loan is underneath. As long as the seller is willing to sell it to you, maybe loan in their own name, there's nothing to stop you from buying it. In fact, the worst that the bank could do is call a loan due, but they won't. As long as that payment is being made, they won't. Now, I can't guarantee you they won't, and you can't guarantee the seller they won't, but they won't because they don't want houses. There's 2 loans that you need to be concerned about if you take them over or wrap them or whatever, and that is lines of credit and reverse mortgages. Reverse mortgage, if the bank finds out, will probably call that loan due. Line of credit, they may or may not. So if I were going to take do a wrap on either one of those, I would consider it a short-term deal. And when I put my tenant buyer in there, I'd only give them about 1 year to cash me out, and that's plenty of time. And anything that happened during that year, you could easily stall it off till that year is over. I mean, that's a very short version of that answer, but
Okay.
best I can do for now.
And then his next question and last question is, I like to put my personal home in a land trust. Can my living trust be my trustee?
No, I don't want your living trust to be on public record for any reason whatsoever. What state was he in?
He's New York.
New York? Well, you can use an LLC in New York to be the trustee, and it can be your LLC. I'm almost sure of that. So you need to get an LLC if you don't already have one, and if you do, there's your trustee. In Florida, I use one of my own LLCs as trustee. And worst case, you use somebody else as trustee as an individual. Prefer you don't use somebody with your last name, but don't ever use your living trust. I don't want your living trust anywhere near public record, ever. Okay? So get a human or get an LLC. You're going to need one anyway. You might as well get an LLC.
Okay, that was our last question.
That's it?
Yep, that's it.
That's all there is? Okay. All right, well, good questions actually this week, guys. Better than most. So keep them coming, and we'll keep answering them. Let me see. Where am I going to be next week? I'm going to be in Dallas, so we'll probably do one from Dallas. Or will we? No, that's this week.
Yeah,
Excuse me. Okay.
Week.
Next week I'll be home. I forget where I'm at sometimes. Sometimes I get out of bed and where the heck am I? Then I have to look at the hotel to see where I'm at. I'm just kidding. I'm not that absent-minded yet. All right. Anyway, go get some deals. I'll see you next week.